Okay, so like then, who would be like the Aquaman of NATO?
I think Canada.
Yeah, Canada.
It's like they're in the top tier, but not the top tier. They want
Yeah,
to be big.
like you've got Superboy, and they're not really Superboy, but not Superman yet. They're just kind of in between. They're in a weird spot.
Yeah. Hey everybody, welcome back to another episode of Hail State Debate. I am Brett Harvey, coach of the MSU, Mississippi State University debate team. I've got Josh McCoy, our ace varsity debater, and Alicia Brown, our other ace varsity debater, here to talk about public forum debate. So if you don't know, Hail State Debate is the channel where we discuss LD and PF topics, try to provide some insight and some thoughts about just, how to approach those topics and good debating in general. And we are kicking off another year now with the very first PF topic for September and October of 2018. And it is resolved: the United States should accede to the United Nations Convention on the Law of the Sea without reservations. That is a kind of a mouthful, to say the least. So before we kind of get into it, guys, y'all want to do some initial thoughts on the resolution? I'll do mine. Okay, let me do mine and y'all do yours.
Yeah.
So my thoughts on this topic are that it is a complex topic, a multi-layer topic with a lot of information to cover. If I'm being perfectly honest, I might say that it is maybe not the best topic you could possibly choose to start the year off. I do think novices are going to be a little intimidated by the breadth of it, but not just how broad it is, like how many areas, like different international disputes are involved, but also the depth. Because one thing that I have not seen discussed about it yet is just the issue of like international law. Like you really need to understand how international law works to have an appreciation for like how this agreement affects, and honestly in some cases doesn't affect issues. And I'm just concerned that there are so many layers it can be tough. But we are here to try to simplify that. So I mean that's kind of my view. What do you guys think?
Well, I think the biggest thing for me is I think I would be fine with debating a resolution like this in the style of debate that we do.
Yeah.
But when it comes to public forum, whenever you've only got 2 and 4 minute speeches, you've only got 45 minutes total to talk about all of this. There's not a whole lot you can do, and you can't be, kind of abusive with the definitions because everyone has ground for it. You're just going to be very careful about it and have a very wide knowledge of on this topic, like Brett was saying.
Especially if you're in a circuit with lay judges, you're going to need to take at least a minute to outline what the United Nations Convention on the Law of the Sea even is, what it implies, and then getting more into the nitty-gritty of like whose interests are we considering, whether those of the United States or those of the world, and also what without reservations means, when reservations are allowed in international law, and what that might look like.
Yeah, I mean, I think that's super important. Like a lot of times, a lot of even very good like PF teams I've noticed come in and kind of assume a lot of knowledge on the part of the judge. Like, and in some cases, like if it's plea bargaining or something like that, I mean, I think most people know what that is, and that might be okay. But on this one, as tough as it is to set aside a little time somewhere in that case to basically explain in clear terms, I would say you do need to have at least a version of the case ready to go to do that. Now, if you've got somebody who was a PF debater 2 years ago and they've judged 10 rounds on it already, maybe not. But yeah, I think explaining clearly what this whole international, shindig we're talking about is super important.
Right. I mean, if you're taking, hours and hours to research this, imagine what it's going to be like to your judge who may be seeing this for the first time in their life, and you just come at them right out of the gate with a bunch of technical jargon.
Yeah.
They're going to be lost.
Exactly. The big part here is going to be making this relevant to your judge, because most people don't sit around and think about the freedom of navigation of United States ships or the sanctity of resources. No one sits around and thinks about that at dinner time.
I do.
For us,
I mean,
yeah.
We do that all the time.
We do,
We've had to for the last
we've
week.
had to
But
for
anyway.
the last 6 years.
But okay, so to get us started then, the overview is going to be kind of what we're going to do. We're going to do it in 4 sections. We usually do videos of about an hour. We're going to break it into 4 sections so that you can kind of either watch it all at once or you can watch it a little bit at a time. So first we're going to do a topic overview. I'm not going to spend a huge amount of time recapping the details of UNCLOS, the United Nations Convention on the Law of the Sea. We will talk about it briefly. There are tons of sources you can learn about that on. Probably better read than maybe discussed in a video, but we will go over the basics. Second, we're going to do sort of an inventory of the arguments. There are so many different ways you can come at this, and that's one of the reasons why I think it might not be the most ideal topic. But we've got, we got to saddle up and deal with what we've got, right? So we're going to take an inventory of them and kind of lay out what some of the major arguments are. and just kind of discuss what the major issues are. And then we're just going to take the next two sections. And Alicia, I think you're going to be our sort of representative for the pro generally. And then Josh is going to have a segment on the con. But we're going to go back and forth because, like I said earlier, there are tons of layers on this. It's like a game of chess. I mean, it can all turn in one move. There are lots of ways to turn arguments. And we're going to talk about that. So, without further ado, I guess it is time to start talking about UNCLOS, the United Nations Convention on the Law of the Sea. So basically, United Nations Convention on the Law of the Sea is an international agreement. It has about 130 parties to it. The majority of countries in the world are members, and essentially what it does is it provides a framework for apportioning rights and obligations with respect to the world's oceans and the world's seas, and also coastal waters and things like that. The convention, actually, when we say the convention, what we're also referring to is the process by which it was adopted. It's interesting that this treaty was a 9-year process. So it was actually, the convention was convened in, I believe, in New York in 1973. And this document, UNCLOS, which is a 200-page, give or take, treaty, was not actually brought for ratification until 1982. The United States, interestingly enough, was a leading force, one of the leading forces in the negotiation. Although in 1982, when it was actually put up for ratification, the Reagan administration said, we don't think we're gonna sign this thing. We're not going to be a party to it. Now that doesn't mean, as we're going to talk about in a few minutes, that does not mean that the United States does not follow, quote unquote, the law of the sea, because there's a difference between the law of the sea and UNCLOS, right? The law of the sea, many international law experts would argue, is something that has existed for decades, if not centuries. It's gone back as long as people have been navigating the oceans. And we follow, I'd say probably about 95 to 98% of the stuff that's written down in UNCLOS. And we have since 1982, but we did not sign it. Now, in 1994, this is an important historical point. In 1994, and you need to be aware of this, there was a major revision, a major amendment to many of the provisions of UNCLOS. One of the biggest issues that was addressed was technology sharing. So among the many other things that UNCLOS addresses, things like territorial waters, who has the rights to the high seas, freedom of navigation, where can boats go, when can they be boarded, when do they have to ask permission? The answer is almost never, right? Environmental regulations, all of these things are covered, but one of the big things was technology sharing. Folks didn't like the idea of having to be compelled to sell their technologies for mining the seas to other people. So amendments were made to sort of fix these problems. And those amendments persuaded a lot of countries to come on board and sign the agreement. And that actually, 1994 was when enough countries, I think the threshold was 60. 60 countries had to sign it before it came into force. And so it was actually 12 years after it was put forth for ratification that enough countries signed it for it to come into force. So if you think about this, this was a roughly 21-year process from 1973 to 1994. It finally came into force. And the United States actually signed it. President Clinton signed it. But as you know, or I hope you guys know, you're taking civics classes, right? To formally ratify and adopt a treaty, accede, the word is accede to a treaty, it's not just the president signs it, the Senate has to ratify it, right? The advice and consent of the Senate. That means the Senate has to ratify it, and the Senate has never ratified it. It has come before the Senate many times. There are, as we'll talk about later, many people who support it, but it has never been ratified. And the reasons for that, I think we're all going to talk about it. They're basically the idea that the United States needs to be sovereign. The United States needs to be able to not be subject to the rulings of international tribunals. But like we said earlier, there's lots of provisions: freedom of navigation, exclusive economic zones. In other words, places where you have the exclusive right to go and exploit resources, and it kind of diminishes, like in coast-centric circles, like moving out from the coast. Like you have, for example, over certain territorial waters, complete right and control, and then as we go further out into the exclusive economic zone, it kind of diminishes. And you may say, well, Brett, Alicia, Josh, why aren't you spending more time going through the very, very particular stuff of these like exclusive economic zones? And the answer to that is
there's no way that we.
Well, yeah, number one, there's no way you can do it in an hour-long video. But number two, it really shouldn't be that important in this debate because, like we said earlier, and we're going to talk about later, the United States already follows these laws. They follow most of these things about territorial waters as a matter of what's called customary international law. In other words, kind of informal international law. They have for many years. So But it also has things about environment and pollution. And one of the most important areas is the creation of tribunals and dispute resolutions to resolve disputes over things like territory. The South China Sea is going to be an important thing we talk about. The Arctic region is going to be an important thing that we talk about. And it has all of these provisions, and we've already followed most of them. There are some we don't, like mining the deep sea floor. But, having said all that, I mean, did we basically, I think we covered, that's sort of a general overview
It's
of
a
what
good
it is.
overview.
Okay.
Some topic analysis
Thank
now
you.
would be good.
Yeah, so to sort of analyze, how the topic works, I was going to, kind of start by talking a little bit about, I think, international law. And, one of the things I think is really important is that you have to have a sense of how international law works to be able to argue this topic effectively. And I'm worried that like lots and lots of teams are not even going to take the time to learn anything about this. They're going to be so consumed with like the big impacts of things like Russia and China and that sort of thing that they're not going to do it. And so I got a slide here, and it just sort of says, I'll pop this up, it's how the law works. And, we live in countries where we are citizens, and the law is basically there are people who make laws, and if you don't follow them, people in, police come and arrest you and take you to jail, right? That's not how international law works. International law is more like about consensus, right? It's more about, because there is no sovereign. Like in the United States, there's a sovereign government, right? And if you don't do what the laws they make, then you can be taken to jail. But in international law, there is no sovereign, so all of these rules have to be based on consensus. And what that means as a practical matter is, if you think that something ought to be considered an international rule, either maybe it's written down in a treaty, or if it's not written down in a treaty, maybe it's part of what we consider, customary international law. If somebody doesn't want to follow it, then your only real option for forcing them to follow it is ultimately, you can try to pressure them, you can try diplomacy, but ultimately, if they just say no, you've got to decide, do I really want to, well, I'm willing to go to war over this, right?
There's no overarching international body. There's no Justice League stepping in and enforcing laws that, if someone violates international law, it's just kind of an agreement.
Well, I mean,
everyone's kind of coming together and agreeing it's an unspoken thing that we should probably kind of do.
And the more powerful you are, the more likely you are to get away with violating an international law or just refusing to go along with something a tribunal says.
I'm glad you both said that. I'm glad you mentioned the Justice League and how powerful you are, because it's kind of like this analogy. Like, imagine the Justice League sits around a table, right, and they make rules, right? And one of the rules is like no stealing food out of the refrigerator, right? Well, if this were like regular people and the police had this rule, then you steal food out of the refrigerator, the police come get you. I mean, that's kind of extreme, but you get the idea. Like some authority comes and stops you. But if Superman wants to steal food out of the refrigerator, there's not a whole lot they can do unless they want to like band together and Batman wants to build like a super suit and like just try to take down Superman. And so you kind of just have to decide, is it worth fighting over this? And in the overwhelming majority of cases, it's not. And as you can see here, this example I use, the Universal Declaration of Human Rights, one of the most foundational documents in international law. The other document I have on the slide is a list of the number of times just in 1 year that the United States arguably violated the United Nations Declaration on Human Rights. And I only have one page. This thing's like 10 pages long. Well, is anybody coming and kicking down the United States door and saying, well, you're in trouble? No, because it operates based on consensus. And I can even take it a step further. You say, Brett, well, that's just an international agreement. It's not like an actual order from like an international tribunal. The truth is that that major powers ignore the decisions of international tribunals and ignore international law left and right all the time. And the best example I have of that is this article from The Diplomat in 2016. And what it talks about is how China is going to ignore this was in the past, but China, it predicted that China would ignore the Hague Tribunal's decision about the South China Sea and its territory. This was a decision under the Law of the Sea Convention, and the article predicted China will just ignore it. And they said, you know how we know China will just ignore it? Because all major powers always ignore international law decisions that are adverse to them. And as you can see this quote, it's amazing. None of the 5 permanent members of the UN Security Council have ever accepted any international court's ruling when it was against their view. They just ignore it. They just don't do it. And that's exactly what China has done with the Hague Tribunal's decision on the Law of the Sea. So one of the big factors you have to take into account in debating this resolution is how much are the impacts watered down? How much is the change nullified by the fact that major powers just say, hey, what are you going to do? You're going to go to war? You going to force us to do this? No, you're not. We're just going to say, we kind of interpret it a little differently. We don't see it that way. We're going to do what we're going to do.
And then you've got the whole problem of things like the reservations inside UNCLOS and stuff like that makes it that much more complicated, because then, maybe they're not just saying we're not going to do this. They may be saying, well, according to one of our reservations, we're allowed to do this. We're allowed to not follow whatever jurisdiction you're giving to us.
Of course, those reservations have to fall within the rules that dictate what kind of reservations you can have. And in this particular treaty, it's Section 298, and there's 3 that you can have.
And it gets really complicated really fast the second you start going down this rabbit hole. So you need to be very well versed and prepared for stuff like this.
That actually leads to kind of the last part of the framework in the overview, which we kind of need to talk about how you're going to frame the resolution, because we've kind of talked now about how international law gets ignored a lot. It gets ignored left and right, but we still have to decide, like, how are we going to define the resolution? How are we going to frame it for the judges? And the biggest question I think you have to start with is just the overarching question of, like, whose interests count. Because I think there is a kind of an assumption or an unspoken belief in a lot of, I've just kind of been reading what folks have been saying about this, some of the briefs that have been put out and some of the stuff they say on, like, Reddit and places like that. And there seems to be an assumption, not everybody, but a lot of people think, like, we're talking about what's in the United States interest. So when the pro says we should exceed, they should be talking about, like, why exceeding makes the United States better off. And when the con says that we shouldn't, they say this is why it doesn't make the United States better off. And I think that there's another major side to that debate. I mean, I think you can say a lot more about it than just assuming that.
Right.
For example, if I were, I guess if I were I'm not sure which side I would be in this case, but there's a very strong argument that the interests of the entire world should be taken into account.
Right. And that's what I was saying. Like, it would be easier for us to debate this in IPDA, because we could just say, oh, we're talking about the U.S. federal government, or we're talking about interests of the whole world, and you could just define it like that. But under this resolution, you're going to have to make an argument one way or another about who exactly the actor is in this case. And it's going to get real messy.
And it completely changes the kind of case you can run, because if you're arguing that the interests of the United States and the United States government is most important, you need to show how this benefits our economy, our national security. But if you're looking at it on more of a world scale, it's like, how do we lend credibility to international law? How do we maintain stability? How do we prevent war?
Yeah, I mean, another way that I would frame what you just said is almost every argument can be turned if you believe that there is an argument that the world is a better place when the United States is less influential and less hegemonic and less dominant, and maybe uses fewer resources and maybe burns less carbon.
And there's almost a guarantee that turn exists somewhere.
Sure. I mean, of course there's literature like that. We'll probably drop some in the notes, but you almost don't need us to, because, like, there's tons of arguments that the world would be a better place if there was more of a multipolar quasi-democratic order, right? With multiple countries. The United States is less of a hegemon. The United States has less ability to impose its views. So, for example, if the pro comes out, and this is just one way the pro could do it, if the pro comes out and says, there's all these tangible benefits, for example, to the United States being able to go develop all these resources and have its navy sail all over the world unfettered and unhindered, one potential con response is the world is better if the United States doesn't go digging up the seafloor and doesn't go growing its economy, which produces all this carbon, and has a bit of restriction in terms of where its navy can go, because
yeah, and then, you've got terms it's like, okay, well, if we don't, maybe some other actor who's going to have far worse environmental policies is going to do the exact same thing, yada, 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 and it's just an endless vicious cycle.
Yeah, right. And I mean, so, I think you have to argue about whose interests count. The difficulty with that is you kind of have to link that to something in the resolution, and there's not like a super strong foothold in the language where you can really clearly say, here's what the resolution dictates in terms of the wording.
It's the United States, not the United States federal government, or some other thing that specifies something that you can, like, have a handhold on.
If you want to narrow it in that way, if you want to narrow it to the United States federal government, scope it back to the fact that all treaties must be ratified by the Senate, and with the Senate being the representatives of the people with the explicit purpose of representing the people in their best interests. That's the strongest argument you can make there.
And not just that, they're technically the only ones who can make the United States accede to this convention.
And that's the basic argument, which is like yes, there's only one possible actor here, ultimately, because remember, it's already been signed. And so the only actor that can do anything is the Senate. So the Senate is representative of the American people. You could argue that they're just the agents of the American people and that they have to do what's in the interest of the American people. Now, the counter to that is, the judge has fiat power. I mean, I know I'm getting a little technical, and we don't use these terms in the round in PF, but like you could also, on the contrary, argue because it says the United States and not the United States federal government, you, the judge, could be sort of the decision maker for like what the people of the United States should want.
Right.
Like, and the people of the United States sometimes do things that are not in their immediate best interest to help others all the time. We do international aid all the time. Whether it works, whether it ends up making the world better, who knows, but we do it all the time. So you could say, no, just the fact that it says United States, that's just what the United States people should do and should believe, right? So,
and the argument either side can make basically off that is, well, who knows, maybe it could help us, maybe it could help the entire world, yada, 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 anything like that.
The key takeaway here is you do need to define that early. You need to define who's the actor. And another thing that you need to go ahead and define is what reservations are allowed. And moving into our next topic.
Yeah, reservations are important. So the topic committee decided to explicitly put the phrase without reservations into the resolution. And so it's important to know what reservations are. Some of the initial discussions I saw on this were talking about reservations were just like sort of the generic meaning, like I'm not too sure about this. I don't feel like maybe I really want to do this. Like I have do you have reservations? Yes, but I'll eat here anyway. Haha, sorry, it's a dad joke. But like it's not that. Reservations have a very specific meaning in international law. It's a term of art, and the best source on it actually is this. It's the Vienna Convention on the Law of Treaties, Article 2(1)d. The Vienna Convention is actually kind of the law that governs how we interpret words in international agreements. It's kind of the overarching law about the law. So it's going to be the most authoritative statement. And it's just a unilateral statement, however you phrase it, by a country where they say, hey, we're going to sign this treaty, we're going to sign this agreement, but we're not going to do the following things. We reserve the right to not do the following things, right? So we'll do it, but we're not going to do X. We'll do, 99 out of 100 things, but here's one thing that we won't do.
It's essentially a line item veto. You go through and you're like, I like everything in here except this line, so I'm just not going to do it.
Yeah, and there's also an interesting part. If you look further in the Vienna Convention on the Law of Treaties, there's Article 19. It actually tells you like when you can do reservations. So some treaties allow you to do reservations anytime you want. They just say, okay, you can just take whatever you want. It's like a buffet. Take this part and that part, but don't take the other. But some treaties, including UNCLOS, have a clause that specifically says you can't do reservations, right? You either take it or leave it. You take the whole thing or you take none of it. So arguably, using the phrase without reservations was kind of superfluous because the only way you can actually accede to UNCLOS is without reservations. You either take it or leave it, with one major exception, right? And so the major exception is Article 309. And Article 309 of UNCLOS basically says no reservations or exceptions may be made to this convention unless expressly permitted by the other articles. So, are there other articles that say that there are maybe some reservations you can make?
I think there probably are.
Maybe there are.
Section 298.
Seems very specific to not have something like that in it.
Yeah. You wouldn't say that unless there were. So yeah, you're saying Section 298. And Section 298 specifically says, hey, look, you remember how we said you couldn't have any reservations and join this treaty? Well,
you can have 3.
There are 3. There are 3 reservations that you can have. The first is basically what you can do is if you want, you can reserve the right not to use some of our dispute resolution proceedings, right? So, for example, if you don't want to come to our compulsory arbitration or come before the Hague or come before any of these international tribunals that we set out to, for example, resolve territorial issues or issues about navigation or boarding ships, there are 3 cases when you can opt out, like you can reserve the right not to. The first is disputes about sea boundaries, right? The second is disputes about military activities of government vessels and law enforcement. So like national security, military, law enforcement, drug interdiction. You can just say, hey, we're not going to do that, right? And then the third one is stuff that could fall within the jurisdiction of the UN Security Council. So here's the question. If you accede to the international, to UNCLOS, right, but you do all 3 of these exceptions, we'll call them exceptions just for now, are those reservations? And if you do them, does that mean that you can basically say, yeah, we like UNCLOS, right? That it's great, but we're going to do 3 reservations. And in that case, does the con win? So let's say that the con comes in and says, okay, the pro comes in and says, law of the sea, UNCLOS, it's great. Here's all these wonderful benefits of it, right? And then the con comes in and says, we agree. We're totally fine with that. We think UNCLOS is just absolutely wonderful. but the resolution requires that it be acceded to without reservations. So what we're going to say is that there are 3 allowed reservations, these 3 that you see in 298. And we're going to run a case that says, hey, 1, 2, 3, here are the 3 reservations. If you agree with any of these 3, right, then that is not without reservations, that's with reservations, and therefore you should vote con. So at that point, you're going to have to get into a debate about, are these things reservations, or are they just kind of things that are allowed in the treaty? And so sort of what the pro would say is they're not really reservations because they're explicitly spelled out in the treaty, right? And what the con is going to say, well, number 1, they're referred to as reservations in 309, and number 2, if you look at the Vienna Convention, it says that it doesn't really matter what you call it, right? It is a reservation is a reservation is a reservation. And I think the pro would come back and basically say it just doesn't make common sense.
Well, also, Article 298 says optional exceptions to applicability of Section 2. So it's not calling it a reservation, it's an exception.
So that is a general overview of the topic. So next what we're going to do is we're going to come back and we're going to do a kind of an inventory of all of the substantive arguments that you can make on this topic. Okay, so since this is such a broad topic, what we thought we would do next is sort of run down just the general areas that you can expect to see. You can kind of think of this as sort of a checklist of the basic areas that you want to be prepared for if you want to have kind of a baseline level of preparation for your first tournament. So guys, you want to start throwing them out? You want me to start throwing them out? I mean, what are the big issues we need to start, getting people ready to cover here?
Alicia?
Well, first of all, it depends on how you scope your case, whose interests we're considering. If you've decided to scope it to the United States, you're definitely going to have a different set of arguments than if you scope it to the entire world.
Right.
That's true. Yeah, so I mean, you could very conceivably be talking about very practical U.S. economic interest, U.S. strategic interest, or sort of a more high-level arguments about sort of like what a better world would look like through having, resolving things through consensus and stuff. So
let's start that baseline. Start with the United States economic interests.
Right.
First thing we can talk about is like deep sea mining, deep sea minerals, and oil and gas as well, particularly in the Arctic.
Yeah, this is a kind of two-tiered argument. It has kind of 2 parts to it. One is just the argument for the pro is we need the framework of UNCLOS to be able to have a claim to drill and to mine for minerals in the high seas. The basic idea is with UNCLOS lays out a framework that lets people sort of claim the minerals on the seafloor. This is generally viewed as sort of the common property of all humanity, but UNCLOS provides a mechanism by which you can go and sort of lay claim to it.
And that's important because companies, especially in the United States, are not going to undertake an expensive endeavor like going into the Arctic or going into anywhere else in the seafloor and mining when they're not sure that they can keep what they mine.
Yeah, the main problem is UNCLOS, underneath their 6 zones, no one in international waters has any exclusive rights to the resources found there. So if you go to the Arctic to drill for oil, unless you live in Canada or Russia and part of your own territory is in that Arctic zone, it doesn't count as your natural resource rights.
But it's a good thing that you mentioned that, because remember, the United States does have Alaska, which is an Arctic area of our country.
So yeah, basically what I think what you're going to be seeing on this, is the idea that you'll see arguments we'll talk about in just a minute that there actually are other alternate ways, like through U.S. domestic laws and bilateral treaties, that you can gain the right to do mining on the seabed. But I think what Alicia said is important, which is that if private companies aren't comfortable going out and doing, in other words, if they don't feel like the right is secure enough and the law is clear enough, then even if we can say, oh, hey, there's a U.S. statute, and there is a U.S. statute about mining the seafloor out in the open ocean, but even if that's the case, if companies don't feel like their rights are secure enough and recognized enough in international law, we can pass all the laws we want domestically. The resources are not going to get pulled up out of the seafloor.
Right, and to go ahead and preempt Brett's argument about bilateral treaties and domestic laws, you can actually pull evidence from congressional hearings from the CEO of Lockheed Martin, who would be one of the companies that would be mining for these deep sea rare earth minerals. They have said they will not invest in this undertaking until the United States has the firm footing under international law that they have the exclusive right to everything they mine. So that's just one tangible example.
You preempted. I had no idea what you're like. Oh, that was really good. That was like you preempted a better argument than I was going to make.
Well, the other thing is, whenever you start talking about mineral rights and stuff like that, if say you vote for the pro and the pro ratifies UNCLOS and we accept all of the parts of UNCLOS without reservations, the fact is you're going to see this a lot. You're going to see arguments about possible lawsuits over the United States violating some sort of mineral rights if they don't have this very secure footing for what mineral resources we actually have access to.
So next on the agenda is one that's going to come up a lot, which is freedom of navigation. And this is one of those that is going to be, I think, muted a little bit by the fact that it's frankly already followed everywhere. But basically the idea is UNCLOS recognizes the right of vessels to navigate pretty much freely in almost all of the non-internal waterways of the world. So not rivers, not places that are kind of inside like shoals, like off the banks of North Carolina, but really any other waters, you have the right to innocent, peaceful passage of your vessels. And one of the arguments that you make with the U.S. is this is critically important to us because, number one, we're a maritime country in terms of commerce. We ship goods all over the world. It's a huge part of our economy. And number two, our Navy is the most powerful in the world, and it's incredibly important for our national security and our ability to project force around the world that we be able to move through these specific straits and between these archipelagos of islands and places like that without being hindered. That's really important for us to be able to project our force around the world.
But there are some instances where this has been challenged. For instance, as new trade routes open through the Arctic, as the sea ice melts, like you're beginning to see new trade routes that are being controlled by countries that don't necessarily have a territorial claim over that land. And we also see cases in Canada where the debate between what constitutes internal waterways, for instance, between islands and archipelagic waters, is a lot more ambiguous, and that's something that might be better resolved with an international tribunal than, say, a bilateral agreement.
Another thing on freedom of navigation is you kind of have to sort of have a practical reality test. If the pro says, oh, we need UNCLOS, we need to accede to it in order to have the freedom to send our ships anywhere, you kind of have to ask yourself, and this is true on so many issues in this debate, is there a practical scenario where you can see major important countries saying to the U.S., get out of our waters? And more importantly, would it make any difference if we had acceded to UNCLOS or not, right? So the United States has navigational freedom, one would argue, for two real reasons. It's not because we've signed any particular treaty. We didn't have these treaties in place in the 1950s and 60s and 70s, and we navigated, wherever we wanted to. The reason countries let the United States navigate where it wants to is because it's, number one, it's the biggest economy in the world, and you don't want to run afoul of the United States. You don't want to have an embargo or trade sanctions, especially today when we've got a president who's clearly ready to pull the trigger on those things. And you certainly don't want to trigger a military conflict. Right, so you could really argue that if you were going to, say to the other side, well, hey, if you think it's so important that we sign this piece of paper, has anybody ever tried to stop us from going these places? I mean, this treaty's been in place since 1994. We have not been a party at any point. Has anybody actually tried to stop us from navigating? Can you paint any realistic scenario in which they would? And if so, would it make any difference if we signed a certain piece of paper? I just think there's a certain level of realism and practicality where the United States gets what it wants because it's a superpower, right? Not because it's signed a particular agreement. I think you just have to be realistic about that at some point.
We also have to remember that this isn't just about military navigation. One of the points that I would make if I were writing a pro case is about international telecommunications cables. What we see is that if the United States owns an international cable, they have the right under UNCLOS to go and repair it if there's ever a reason for them to need to. But right now, since they're not a party to the treaty, in the two instances that are providing in this example that I'm looking at, that they were challenged on that right, they didn't have a seat at the table to go and argue that out in an international tribunal. They had to resort to their subsidiaries in other countries who are parties of UNCLOS to go and fix those problems and bring that dispute up.
Yeah, and I think that actually sort of goes to one potentially strong argument. A lot of times in debate, particularly in high school, we have this tendency to want to run to the biggest, most powerful impacts in the world. We want to say, okay, what links to climate change? What links to nuclear war, right? And even you read a lot of these briefs and stuff, and they just want to run to climate change, nuclear war all the time. The links are often very weak, and particularly in this case, the idea that nuclear war is going to hinge on whether we sign a piece of paper is ludicrous and laughable. And if anybody says that in a round, you ought to, there are sources that say that, and you ought to pull it and be able, and most judges who are not just hardcore college policy debaters are going to say the idea that somebody's going to say, well, the United States didn't sign this, accede to this. They follow it, they signed it, but they didn't formally ratify it in the Senate. I guess that's the difference maker on nuclear war is ludicrous and laughable. And I think we need to talk more about that in debate, about how just ridiculous that is. But what Alicia's talking about is something that's much more practical. It's about the ability to get certain countries to let us in within a frame of hours instead of a frame of months and weeks to repair certain cables. And that is something where being a member of a particular international order that has, set ways of resolving these disputes, that is plausible. That could make a difference.
And also, building on that point, in many cases there are technologies that are emerging and that involve the ocean, and there isn't yet an international authority on that. And undersea cables is one of those. For instance, right now there is no international punishment, no international proceeding that occurs if someone sabotages a cable, even though by their very nature, if you sabotage a cable, that could affect the entire world, the economies of the entire world. So the U.S. could take the lead on something like that, but being an UNCLOS would be important.
Yeah, and I didn't mean to suggest it was a small impact. It could be a huge impact. I mean, I get it. You got to try to link things to sort of these big impacts, and you can link it to shutting down computer networks and terrorism. But even if you didn't, even if it's accidental, we just get the internet back up, days faster.
But I mean, if an electric outage costs you hundreds of millions of dollars,
a day,
about a
like
global
a day.
Scale.
Yeah, absolutely. I think that's good. Next one on the list would be South China Sea. South China Sea is really just another way of saying dispute resolution procedures. In other words, South China Sea wants to build artificial islands, wants to claim territory within the South China Sea. It's been opposed by the United States. It's been opposed by just about everybody.
Yeah.
The problem with this argument, we see it popping up, is that it just seems to be kind of a nullity because these claims, at least some of the claims, not all of the Hague Tribunal heard this case in 2016. It did not have jurisdiction to hear every possible argument because China hadn't consented to every possible argument being heard, but it did have jurisdiction to decide about like the geographic features and whether or not China had a legitimate claim to own certain areas because of like the geography of the seafloor and these islands, like the Spratly Islands. And it just resoundingly rejected all of China's arguments, like unanimously told them, nope, sorry, you have no... China, and China, by the way, is a member. It has acceded to the Law of the Sea Convention. And it told them, nope, sorry, you don't have the ability. China immediately turned around days later and said, we don't care. And this is like what we said earlier. There's never been a case where an international tribunal told a major world power, a member of the UN Security Council or other major world powers, hey, you've got to do X. And they just said, oh, well, I guess we've just got to give up our territory because some judge in, Brussels or Dusseldorf or Germany just said, oh, well, some guy told us we had to. I guess we have to. They're not going to do that, and they didn't. And I think that you may have people run South China Sea, but honestly, South China Sea just illustrates how, frankly, impotent and weak and toothless Law of the Sea can be, in my view. I don't know what you guys think, but
Well, right, but I mean, the thing is, I think especially on the con, one thing you're gonna have to look at is instances like the South China Sea and make a comparison between the cost and what the actual impact or benefit of ratifying UNCLOS would be for the United States, and whether or not you look at it like Alicia's trying to, with just the scope of what the United States should do, being like, say, our judge is a senator. With a wave of magic wand, they could ratify UNCLOS without any reservations. What is the impact of that? Is this enough to warrant a pro vote? If there's any disadvantage you can come up with on the con, be it loss of hegemony, loss of freedom of navigation
so
rights.
Much of the evidence that you read when you read this is talking about how, well, the United States is calling out China for violating UNCLOS, right, even though we're not a member, and we're hypocritical. And I agree. I mean, that's true. We are kind of hypocritical, but like...
But what else is new?
Well,
yeah.
Also, we're following most of it anyways. We just don't want to put our name on a piece of paper because... I don't know. I guess we're wild child rebels.
Yeah, well, I mean, we are. We're America. Heck yeah, right? But I mean, what would the difference be? That's the question. Like, what would the difference be? Would China say, "Wait, what? Oh, they acceded to it? Oh, they're a party to it." Well, of course.
Well, I mean, we were going to disobey,
here, right?
But now that the United States has put their name on it, I guess we won't.
All of the evidence you read on this says this sort of weasel word stuff like it will give the United States additional credibility. It will raise our stature. Okay,
what does that mean?
Well, first of all, we're a country right now whose president has no problem risking nuclear war to call a guy fat on Twitter, right? So I don't know. I think to me, like, credibility has kind of already flown out the window. I'm sorry if you don't agree, but I mean that's the way I feel. But secondly, what does China care about our credibility? This is the future of this is their territory. This is their economy. This is their claim to power in the world. They don't care. Show me a piece of evidence where somebody says something other than just like weasel words, like it will raise our credibility. China doesn't care about our credibility.
The point is, the pro is going to be bringing up a lot every time we try to ratify UNCLOS. ask them to quantify the impact for you and for the judge. And if they can't do it, say, well, judge, listen, sure, you're providing credibility, maybe, whatever that means, but what's the impact of that? You have no idea, so it shouldn't be something to vote
show
on.
me a quote where some official in China or Russia or whichever dispute we're talking about gave some indication somewhere that the result would be different. This $1 trillion resource thing that they're looking at, right? This territory where they can make huge use of it, that the result would be different if we remember. Show me somebody who's not just some academic using some tepid quote where this might improve our credibility. I mean,
U.S. soft power in the region is going to massively increase.
Come on, give me something to measure here. I mean, they don't care. Okay, I'm sorry. I know I've gone on about this.
Right.
So
but it's going to come up a lot. It's going to come up.
But there are some concrete impacts in reserving our seat at the table. Because right now the United States is one of the only countries that has a guaranteed seat at the table for this.
And there are
so
concrete
for emerging
impacts.
technologies, that's something that we need to
Okay, well, actually, I want to talk about that. I want to talk
reserve
about that. So hold yours just for a second,
Okay.
Josh. So another one on the list is, I think a pro argument is the seat at the table argument, which is like, okay, here's the thing. Whatever you think of UNCLOS, right? However weak or tepid or whatever word I just used is, like, however kind of meaningless it is a place where 130 major powers, almost all the major powers but us, get together and make decisions about what can be done in the sea and what cannot. So there is a strong argument that the United States says, you know what, even if we're not crazy about some of the details, we already follow like 98% of it. Why not just go ahead and we're basically in the club. We followed most of the club's rules. So why not show up for the club meeting so we can vote on the club rules, right?
Because the thing is, and what I'm going to say is the con of that is, well, being able to be at the meeting, being able to vote means you're also liable for any infractions you actually have. Opening the floodgates,
toothless.
opening the floodgates for lawsuits from international tribunals and
I'm
other.
glad you mentioned lawsuits.
And I know
because we've had the Secretary of State's legal team look over this convention, over this treaty, and they have concluded that there is no way that this holds us liable for lawsuits. So I mean, you can go with some academic who's like, it might open up for lawsuits.
Yeah, they said that right now because what they're looking at is ratifying UNCLOS with the reservation still in place, because those reservations prevent us from the lawsuits. But if you're voting on the pro, that means you're not going to have those reservations that the Secretary of State is probably relying on.
Joshua, can you explain to me how the reservations in Section 298 prevent lawsuits when they're about the borders of the
disputes
sea?
about sea boundaries.
Sea
For instance,
boundaries.
if we
that
go,
has
if we
nothing
go,
to do with
All right,
carbon emissions.
time out.
or-
Time out. Okay. Yes. Very good. I mean, this is how sort of like this can be an emotional topic. I know you guys really care a lot about the law of the sea, right?
care about mineral rights, man.
I get that.
Man, I'm just like upset about carbon emissions.
Yeah, but like, okay, so I mean, the basic argument is, and if I don't mean to be cynical, but here's how it could play out in a round for real, just to kind of bring it back to focus. We should have a seat at the table, right? And the response is, well, if we have a seat at the table, we're going to subject ourselves to lawsuits. And the cynical but probably true pro response would be, no, we won't. I mean, we might get sued, but you know what we're going to do? We're going to do the same thing every other major power has done in that diplomat article we said, which is like, go ahead, sue us, knock yourself out. But if a judge in, Brussels comes back and says, or The Hague comes back and says, yes, you owe $10 trillion a year, because of your carbon emissions, we're going to say, hey, okay, thanks.
Put it on my card.
We're going to say, like, cool story, bro. And we're going to do whatever we want to do, right? So, I mean, honestly, you could make an argument for the pro that this is kind of almost just like a photo op. Like we show up, we say we're members, we make a good show, we hope that we don't get any major sort of lawsuits or anything. We sit in the meetings, we help make the rules. But then if somebody comes along and says the equivalent of, hey, China, you got to give up your claims to the sea, or hey, United States, you owe trillions of dollars for carbon emissions, we're going to say, that's awesome, we'll take it under consideration. And we're not going to do anything. So, I mean,
taking the suggestions box and immediately dumping it into the trash.
Ultimately, frankly, that is the most likely scenario. The likelihood that this leads to like nuclear war or people just like throwing up their hands, I guess we got to give up half of our territory in the world, because some judge said it, is ridiculous. The more likely idea is we get access. We show up for some meetings, maybe change a clause here or there, and then if they say things we don't like, we just do the same thing every great power has always done and ignore it.
Or, worst case, if it gets really bad, we can leave. This isn't a contractually binding contract like domestic law. Here, you decide you don't like it anymore and you leave.
Yeah, I mean, you can always withdraw. The worst case, you could actually, that's kind of cynical, but, a pro could always say, hey, why don't we just run it up the flagpole and see what happens? Just throw it against the wall and see what sticks. Like, let's go ahead and accede to it, see if we get benefits. And if we don't like it, just withdraw. Now, you could say there are costs to that. There's credibility costs. But again, I mean, there's a really serious argument to say,
who cares?
U.S. credibility is already shot.
What credibility, right? And number two, we don't rely on credibility to advance our interest. We rely on the world's biggest military by orders of magnitude and the world's largest economy. That's why we get what we want, not because we're just like, we don't, if this were Civilization, we're not winning diplomacy victories if you play the video game Civilization, right? So next on the list is the kind of the flip side of that, which is like legitimizing UNCLOS, and it helped the United States, rather than gaining legitimacy from international law, by participating would lend legitimacy to international law.
Now, this would be more for a case where you're considering the interests of the world as a whole, like a world where international law is strong and has enforcement and people tend to abide by it.
And I think the problem that the pro is going to face on here is, to run this argument, you're going to have to go on the framework of, okay, should being in terms of the world's interests rather than just the United States. Because it's really easy to win this on the pro side if you're being kind of selfish as an American, saying, I'm going to take whatever I want and not care about the rest of the world. But whenever you start bringing the rest of the world into things, it makes it a bit more complicated and it muddies it up a little bit.
Though I must say, for some of the mining and mineral rights cases, right now China has the overwhelming supply of rare earth minerals. So if there was like a more friendly, human rights interested power that was able to have some of those, like have a supply of those minerals,
or even just the United States, if you don't have one of those.
Here's an example. You can turn pretty much any argument like that, like the DC minerals example, to go for either case. You can show that it's in your interest and it's in the world's interest. I mean, it's kind of like trickle down economics. You say it's going to be good for everybody when really it's just good for you.
Well, the big thing is, it's one side could say, if you're focused on U.S. interests, you could say, all right, look, we need these mineral rights to keep our military strong and to keep, away from the stranglehold of China on our economy. But then the flip side on that, if I was on the con, I would just say, okay, well, sure, you can increase the U.S.'s military, but the world, that's probably not a very good thing. I think you mentioned that at the very beginning of the video.
I mean, you can always flip it and say a weaker, less influential, less hegemonic United States is good. But I actually think rare earth minerals is one exception to that, because right now it's not like the alternative state is either the United States is the hegemon or everybody has rare earth minerals. They don't, right? Really, right now, China has a near monopoly on them. And so even if you think the United States is not the most friendly of superpowers, and it's not. It's always better to like have two for competition. So like, Walmart and Target, like neither one of those is going to be like is super socially conscious, but they have to compete against each other. And if they have to,
Amazon.
What?
At least they're
and
not
Amazon, like they have to, but they have to compete against each other. And you could argue that not only would the United States be better off with rare earth minerals, the whole world would be better off by having two sources, at least two major sources to compete against each other. So I actually think rare earth minerals is a pretty strong argument.
Exactly, and if you want to tie that into the environment, rare earth minerals are essential for electric cars. They're essential for like higher power technologies, like emerging technologies, plus military applications.
Yeah,
so
but to extract rare earth minerals is really harmful to the environment, and then so you can just get into rabbit holes on the environmental impacts.
Last major one I want to put on the list, and then we're going to move on and kind of do quickly just sort of like a pro case and a con case and kind of let them clash, is proliferation. And this is one that can swing either way. So the basic way this shakes out is the United States currently engages in these sort of bilateral agreements with other countries. It's called the Proliferation Security Initiative. And they basically, we sort of try to reach agreements that let our ships, each other's ships, interdict other ships that appear to maybe be carrying things like, enriched uranium or things like that might be used in nuclear weapons or weapons of mass destruction. And there are sort of two arguments on this. The pro might say that, there are some countries out there that sort of are hesitant to enter into these because we're not a member of UNCLOS and because it is so linked to the interdiction provisions of UNCLOS.
There are actually speeches from foreign ministers that say that exact thing. So the evidence will not be hard to find there. So
there's the pro argument there, and there's plenty of evidence on it. There's the con argument, though, that says that, hey, under UNCLOS, we do not have the unilateral right to interdict ships without, in certain cases, under foreign flags, even in our territorial waters, unless we ask permission, and so the argument would be it would hamstring our ability to interdict ships that have weapons of mass destruction, chemical weapons, biological weapons, nuclear weapons, and things like that. I think the core response to that latter argument, which is kind of a con argument, is, again, let's be real. Can you imagine a world in which, first of all, the Vienna Convention on the Law of Treaties, which we mentioned at the beginning, specifically says that any international law, any agreement you enter into can be suspended. Your obligations can be suspended, right? If if it's for national security concerns.
And every single time that's been brought up, nations have literally never accepted international court rules.
Yeah, exactly. And number two, one of the reservations that you can make to your own to UNCLOS when you enter into it is to military interdiction, right? So military activities. So there's sort of two levels by which you could say the United States could offer either of these two things. It could say just either A, we have an intrinsic right under international law when we're talking about national security, and clearly weapons of mass destruction are that. And secondly, we can reserve the right to not ask your permission and not go to your tribunal in cases of national security and military activities, right? So the realistic argument is, can you envision any scenario where the United States doesn't do that, where it has this ship steaming through the Gulf of Mexico with plutonium on it, and they're like, I wonder if we should interdict that ship or not? Well, we would, except that I'm just not sure that we can do it because we remember we acceded to the law of the sea treaty. I guess we've just kind of let them take that anthrax or whatever it is wherever they're going. It's not going to happen. It's just not going to happen. The United States is going to say, here's our interpretation, here's what we think it means, and everybody else is going to be, yeah, cool, that's fine. You can totally interdict anthrax. That's just how the real world works, right? So anyway. So those are, I think, the basic major overarching issues. Are there others? Sure. There's environmental regulations. There's the issue of royalties. We just kind of are a little bit limited in time.
Yeah, I mean, the fact is you guys are probably going to be looking at briefs, or you're going to find a wealth of knowledge on each of these points online, and you will never be able to bring up all of these points in a single debate case. Just be aware of them and try to kind of have an idea of a counter to them.
Yeah, so what we're going to do next is we're going to do our last couple of segments where we're going to basically look at a pro case, a con case, and then some strategic considerations. And so we will do that in just 1 second. Okay, so now that we've kind of laid out a checklist of some of what the big arguments will be on this, what I'd like to do is let both sides, con and pro, kind of lay out what a case or maybe a couple of cases might actually look like, because frankly, the context of the arguments matter, right? I mean, as Alicia pointed out earlier, where you decide to stand, for example, on whose benefit matters, the world versus the United States, really fundamentally affects what your case looks like. So instead of just sort of putting them out there, or in addition to just sort of putting them out there, I thought that what we would do is talk about what a complete case looks like. And because, frankly, I think we have talked a little bit more about the pro so far than the con, I think we will kick it off with some ideas for what a con case might look like. So, Josh.
Right. So I think the strongest parts that the con is going to want to go over rests on a couple of things. First off, basing the argument off of U.S. interests, because under the UNCLOS, if we decided to ratify it, the general argument is that, okay, listen, we're pretty much already upholden to all of the regulations under UNCLOS. So what's the point of us trying to ratify it? The pro's going to say, all right, we're going to have better accountability, yada, yada, yada. But what's the impact of that? And the impact for the con side is going to be, okay, we're going from a 0% chance of being sued and held up under these tribunals to at least some sort of positive number % chance of being either sued or having some sort of action taken against us. And the con argument is going to be that, okay, not only is this a problem, other things are going to be a problem if we decide to ratify UNCLOS without these reservations. And the big thing is also going to be these reservations.
Well, I think one thing that you're saying, though, is really important to emphasize, which is that I do think that the con strategically is probably in a stronger position if it tries to stake out the idea that we're looking at U.S. interests here. And I think to do that, probably the strongest way to do it is what we talked about earlier, which is to say there's only one actor here. Right? The actor has to be the Senate because they're the only party that constitutionally can accede to it. The Senate's duty is to represent the people of the entire United States, so therefore we have to put U.S. interests first. So I really think, I think the pro has a little bit more leeway to kind of look either way. I think they probably are going to want to lean toward the whole world. Certainly there are some cases, but the con, I think, is just, because, as you implied, it is just really hard to see a lot of major downside for the totality of the world from the United States joining a global agreement to sort of share and get along. There are ways to stretch and make that argument, but on a gut level, especially with lay judges, that's a hard sell, right? And if you lose that argument, you're down the slope a little bit from your opponent. They have the high ground, I guess. It's sort of,
Prequel memes aside. So generally it falls into this idea that we mentioned a couple of times already, especially in the beginning. The fact is the United States already follows what we've been referring to as customary international law The fact is, we've already pretty much agreed on everything that we do across the sea, but the general consensus is that if we ratify UNCLOS, we're going to be limiting a lot of our abilities or a lot of our privileges that we already exercise, and either we're going to be beholden to these tribunals if we continue these practices, and we're going to look like hypocrites, or we no longer continue these practices and we obviously lose some sort of benefit, say militarily or otherwise. So you're going to either want to behold to the three reservations, the big three that we've talked about before, or just generally the fact that we're not going to be as well off as we were before.
Yeah.
The first thing is going to be intelligence gathering. This is a very direct impact of accepting and ratifying UNCLOS. Basically what happens is right now the U.S. is pretty much anywhere it wants to in the world conducting some sort of surveillance militarily via things like submarines. However, underneath the UNCLOS, what's going to happen is it specifically limits intelligence and submarine maneuvers in territorial waters. It says they're going to be restricted and regulated. So by ratifying UNCLOS, either we violate this international law and we are subject to these tribunals, which, let's face it, probably wouldn't happen, but the fact is there's a percentage chance of us being called up to one of these tribunals and either being sued, being fined, yada, 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 or we no longer, we stop these practices or we uphold to the regulations, and we lose valuable military strength.
What could potentially be worse is if we were stopped in someone's territorial waters, they boarded our vessel and found sensitive information about either other countries, like our allies, some of our technologies on those ships. There are circumstances where we could lose valuable information.
Right. And I think something as tangible as a submarine is in an area where it cannot be under UNCLOS is something that, the idea, earlier we were talking about how realistically China's not going to give up a huge section of the South China Sea, but something tangible and specific. There is a vessel going into a place where it should not go. You can absolutely paint a realistic scenario where the United States gets hauled in front of a tribunal, told to do that, and actually does comply with that, and that it is to the detriment of their interests. So that's again, we're talking about the realistic impacts as opposed to sort of crazy things that will never happen.
Right. So even if it's just a small percentage chance, we were talking earlier, just during one of our breaks, some boat rowing up to a United States supercarrier and saying, you must pull over, we have to check your vehicle because they've ratified UNCLOS, it would never happen. But the fact is, there's a chance that if this was discovered, it could become a very, very big problem.
Well, also, there's some ambiguity under UNCLOS with unmanned submarines.
Right.
So,
anything
again, that operates on the ocean floor, if it's in territorial waters, under Article 19, it has to surface if the country that's patrolling that waters tells them to, and that could present
you're either limiting
issues.
Military strategy, or you're limiting deep sea research opportunities. There's all sorts of different things that could be handled just under this one tiny provision about submarines. But then, so remember, we've got the three reservations. We've got certain disputes about sea boundaries. There's a lot of arguments that can be made with this. For instance, I think mineral rights.
Just briefly, let's spell out exactly how this argument works, because we talked about it earlier. But this is, one way that this can work is, look, and this is a very strategic position. But what you can say is, look, the resolution says you have to ratify it without reservations. And so what we're going to do is the con under this case, this is like a separate case. Like the one you were talking about before is just sort of like, what are the best downsides? And the submarine is submarines and the intelligence gathering, that's clearly a downside, no question. But that's sort of a traditional kind of case, a traditional sort of argument. And you can pair it up with other traditional arguments about, things like Arctic drilling. I mean, you can run that up the flagpole and see if it works. But this one is different, right? This is a more strategic case. What this one says is we're really not going to debate about UNCLOS, we're going to debate about reservations, because the resolution specifically says it has to be without reservations. So what we're going to do is we're going to go to Section 298 of the agreement, and we're going to say specifically, here are the three things that you're allowed to put in reservations, and we're going to show you why each of these three things is a good thing that the United States should do. And if you agree with even one, that means what we're doing is we're exceeding with at least one reservation, which means the resolution is not true.
Which means you get all the benefits that the pro might bring up, but you also have the protection from some of the con detriments.
Right.
And that's going to be the best of both worlds. So in this case, the con has a very strategic advantage.
Yeah.
Right. So just a reminder, the three specific reservations that we've talked about are certain disputes about sea boundaries. This can go into stuff like mineral rights, yada, yada, yada.
Yep.
Disputes about military activities or government vessels. That involves both submarines and the idea of, us putting a destroyer out in the South China Sea to circumvent Chinese aggression.
And that's, by the way, a no-brainer. Of course you're going to reserve the right if your military has to interdict another military or fight.
Especially countries like the United States.
You're going to say, look, we reserve the right to not have to go to Hamburg, Germany, wherever it is, and ask permission before we can interdict, terrorists sailing in our waters. Obviously, you're going to do that, and many, many countries already do that.
Well, literally, there hasn't been a country that hasn't reserved that right.
Okay, I didn't know that.
Yeah.
Okay.
And disputes about law enforcement, or third, disputes within the jurisdiction of the United Nations Security Council. The third one is kind of interesting. If I understand it correctly, it's basically saying that if there's anything that would, you could argue falls under the jurisdiction of the United Nations Security Council, rather than any specific tribunal that UNCLOS could be relegated to, you could literally just say, nope, sorry, UNCLOS, we're not going to deal with that. We're going to hand it over to the United Nations Security Council.
like determining if something is a declaration of war, like if
Right.
an act constitutes an act of aggression that could escalate.
Right.
Yeah.
And so if one of those tribunals might say it is, but you say, okay, that's great that you guys think that, we're going to hand it over to the UNSC, and if they say it's not, well, sorry, you're just kind of out of
Certainly,
luck.
if you're the U.S. and sit on the Security Council,
Where, by the way,
it's
we
going
have
to be-
we have a veto. So
it's in your interest. You have a veto, so of course the U.S. would do this.
Right.
Which you might be wondering what this leaves you with as the pro. First off, creatively arguing that reservations explicitly allowed by the treaty do not count as reservations. I mean, if you go against a savvy debater, they're going to call you on it. But most
Plus,
of them won't be
because
that prepared
Article
unless they've seen this
298
video.
They're not reservations. They're optional exceptions.
Yeah, you
Optional
can say they're
exceptions.
optional exceptions. They're not reservations, because if you can't reserve something that is already given to you, and
Right.
the treaty gives you this. So anyway,
There's ways to make that argument, but it's going to be tough for the pro if your opponent runs this case. So
Yeah.
definitely be prepared for some definitional fights, unfortunately.
Right.
all right. So in the
And
interest of
also reserving the right that, if you disagree with the treaty as a nation, since international law lacks enforcement, you can just walk away.
what else you got?
Right. So basically, the argument is, we're about to move over to the pro side because lack of time. But the argument is, look, Judge, if you agree that any one of these three reservations needs to be upheld, and I think the strongest one is going to be point 2 about military activities or government vessels, if you say, look, we deserve to be able to keep anthrax from getting into our borders or nukes coming into the Gulf of Mexico,
Without having to go ask permission from
Right.
from a German
which is
international court.
absurd. Of course,
Right,
we ought to do that.
right.
You should be voting for the con, because the con is saying, yes, we need reservations, and that's one of the
And the
reservations
tactical
we need.
brilliance of this is that it totally sidesteps what is likely to be all of the pros' offense, especially if the pros going first. They're going to run this case about how UNCLOS is so great. You're going to be like, yeah, I agree, UNCLOS is awesome. Now let's talk about reservations. So I concede their entire case. Let's talk about reservations. I mean, so that's one
Alicia, are you going to
possibility.
tell us about some benefits
All right,
of
so
the
with
pro?
that, what are the benefits of the pro? So
Well, going back to the way that we talked earlier about it depends on how you scope interest of the world or interest of the United States. You kind of need to know your opponent. If you're going against the best person at the tournament, chances are they'll probably predicate their case on reservation. So I would run a case that's more focused on how international law in the past is not upheld. And if you want to talk about strengthening international law as a whole, the U.S. joining UNCLOS would certainly be a step in that direction. So that's an argument that I would definitely run. I would almost recommend having 2 cases and hoping to go for second speaker, because I know for me my strategy was always
Yes.
second speaker is better than first.
second speaker is really important.
Especially
on
in this
one.
case, that's going to be incredibly important. I know you're probably going to have a favorite side, but go for second
You're,
speaker.
you're always going to want to be able to play off of
Because
your
if you're the
opponent.
pro, you really need to know if they're going to run a strategic case like this one, or if not. If they're running a traditional case, absolutely. Talk about oil and gas. Talk about rare earth minerals. Talk about freedom of navigation. You can even come up with some really specific cards on that. For instance, we think of Canada as one of our friends, but we currently have 3 maritime disputes with them
We don't
about
know what those
navigational
northerners are
waters.
planning.
So it really depends, but I'd recommend having 2 cases.
Yeah, and so I think that from a practical perspective, one that is sort of a straightforward U.S. benefits case that very simply explains kind of here's what UNCLOS is, here's the benefits we get. There's no real downside. Vote pro. A fairly
Right,
straightforward.
and make sure you
one.
have a very linear argument. First off, okay, we want oil and gas rights access. So let's bring in the Secretary Rex Tillerson's article saying that we will not invest in Arctic oil and gas if we don't have UNCLOS. There's actually a letter from a Senate hearing to that effect. And then say, this is why we need more oil and gas. Or this is why we don't. Or this is why we need rare earth minerals. This is why they're important. And keep making sure that you always have a reason why your argument is important.
And
Because that's something that people miss in high school.
Make sure you have some article from some general saying, no, we don't need UNCLOS because we need submarine surveillance. We need to be able to pass military ships through China.
That's
Well,
gonna
but
be
that's going to be hard
harder to
to find. Yeah, because
Because pretty much everyone
everybody
agrees.
yes.
that
So I
UNCLOS
mean,
is a good
one
thing.
thing I would say on the pro is And as part of the case you just wrote, this is our case that we're going to write for sort of straightforward lay judge rounds, like with judges who are not, debaters. They're folks who are just from the community. And remember, we always on this channel say we love our lay judges. They make debate happen, and they kind of keep us accountable and keep us from going crazy with some of the ways we do things.
They slow us down and make us better speakers.
But they do. They make us better speakers. But we have to make sure we do them the favor of explaining what's going on. But a big part of it is, right, remember, the Joint Chiefs of Staff think unclosed session is a good idea.
Department of Defense.
Department of Defense, leaders of industry think it's a good deal, and that's sort of on the more sort of right wing of the spectrum. On the left, people who believe in the international systems,
leaders.
Environmentalists, they all think it's a good idea. And I hate to say argument from authority. All the smart people think it's good, therefore do it. But in a debate that is as complex as this, with as many different irons in the fire and as many different things, for a judge that just walked in from finishing up their job at 5 o'clock on a Friday night, saying everybody in the world thinks this is a good idea and nobody thinks it's bad, except a couple of crazy people at the Heritage Foundation, right? I'm sorry, I love you guys, Heritage Foundation, but that's what you'll say. This is a debate, right? Then you should do it. I mean, you do have to be able to kind of cut that Gordian knot. And that's one case. I think the other case, as you were saying, is one that's a little bit more esoteric, that kind of is maybe even a little more jaded and cynical, and acknowledges that a lot of this stuff will get ignored, right? But I'd
even be prepared with examples of people who have flaunted international law before, because, every country in the Security Council, China, Russia, the United States, any major power has said, yeah, I'm sorry, I'm just not abiding by this international tribunal.
Start World War III?
What are you going to do about it? Because you've got to, it's like Brett said earlier, when you approach a conflict with another nation, if they say they're not going to abide by international law, your only recourse is to let it go or start a war. So you have to consider, is this worth starting a war over? And most of the time, it's not going to be.
Right. And so you end up with a case that acknowledges that reality. And what it basically says is, look, even if ratifying UNCLOS is just a photo op. We go ahead and ratify it. We go in, we get some good publicity. It makes us look a little bit more reasonable. We get to show up at the meetings and have a say in what's going on.
It strengthens international law, international legitimacy, and then it also allows you to have a seat at the table
and maybe
what's happening in the future.
Yeah, and maybe in a few areas like these in transoceanic cables and things like that, it gives us some specific benefits. But here's the thing. There's not a real big downside, because we know as a practical matter that major powers, if really ridiculous things happen and these tribunals render ridiculous decisions, we're just going to ignore it. And guess what? Nobody's really going to care. Have you heard anybody in the international community coming out and saying, well, China's a pariah, kick them out of the UN, kick them out of every international treaty organization because they ignored the Hague Tribunal in 2016? Had you heard that? Had you heard that before you heard about this topic? No, nobody says that. They're not a pariah.
I hadn't heard that studying this topic.
Right, no, right. Nobody does that. And so we just say, as a practical matter, if we want to ignore the worst parts of it and still get the benefits, we can. It's a little more cynical. It's a little more nuanced. It's a very powerful AF, I think.
Right, but if you want some concrete impacts, you always have the potential. For instance, for the Proliferation Security Initiative, there have been countries that have come out and said, it really doesn't make sense that the U.S. is pushing us to form this non-proliferation treaty when they're not even a part of UNCLOS. And that's definitely a concrete impact where these countries would join if there was more, if they believed in the credibility of the United States.
Okay, well, good job, guys. We're going to now move to our very last section for a couple minutes, wrapping up with a few final parting thoughts, and then we will be done. So, just a second, we'll do that. Okay, so we are going to wrap up basically with a few parting thoughts on this resolution. It's the start of the year. And so I guess the first thought that I have is just remember that your judges may be completely new. They may have never judged a round before at all. That's true at every tournament, but it's certainly true at the beginning of the year. And even if they're not new to PF debate, they're going to be new to this topic, and it's an overwhelming topic. So I guess the advice that I would give you here, that I give to every debater that I work with, is remember, you work for the judge, they don't work for you. Okay? It is your job to bring them to a point where they are comfortable voting for your side of the resolution. And on a resolution like this, that's going to mean very carefully summarizing and educating them on what it is about in a respectful way that gets them from, I have no idea what this is, to I understand it, to I'm prepared to, I see the difference between the pro and the con, to I'm ready to vote for you. Mm-hmm. And that takes a lot of work. I mean, it takes a lot of research to be able to say something well in 4 minutes, even on a simple subject.
And I think, Alicia talked about this a good bit. You're going to have to take 30 seconds, 45 seconds, maybe a minute to really go into the background on this and make sure they have a good understanding and a good grasp of what this is.
Yeah,
there's a lot.
It would be exceptionally foolish, I think, if you were to just jump in and start listing advantages without a very clear discussion of what unclose is. Now, let me be clear. Later on this topic, you might be the sort of person who asks the judge, I was just going to ask, how many, you mind if I ask, like, if you judged a lot of rounds on this, that sort of thing. I just wanted to ask just so I didn't waste your time by, recapping what it is. And if a judge says, no, I've judged 10 rounds on this is the fourth tournament.
Don't ask, what's your experience?
Yeah, don't ask that. Don't ask them what their qualifications are. Don't be that
But
kid.
if it's out rounds, like, they've heard it before, you can skip that.
Well, maybe. I mean, it depends on the tournament.
Yeah, because normally we like to keep like one lay judge and maybe two
if you're at a big like national circuit tournament, where the judges are only judging PF, sure. But at other tournaments, it might be the person, your out rounds might be on Saturday, and these are just the people that showed up on Saturday.
That's fair.
So
you've got coaches and stuff who have kids in the round, so they can't judge. You can't get the super experienced judges that have seen it before.
Yeah, so I would say, ask. I mean, and that's what, as Alicia said, having a couple of cases is a good idea. But so that's number one. The second idea that I have before I let these guys sort of tell you is take the time to really read up, not just on the convention. You're going to have to do a lot of research on all the different provisions and write a bunch of blocks. There's no way around it. I'm sorry. This might not have been my first choice of a topic to start the year, especially, God bless you, novices. I mean, I don't know what to say to you, but I promise you
good luck.
It'll get easier, I promise. But remember, we're going to drop most of the sources, not all the sources that we cite, in the comments, in the notes below. So there will be links to all these sources. Take the time to go down, take a look, especially on some of the things, not just about UNCLOS itself, but also about how international law works, right? I'm going to drop some summaries of how it works. And please be sure to understand how, frankly, major powers do and can and often do ignore international law and what that means for the implications of the debate. Because if you can explain and understand that, there's a whole other dimension to your case that teams that are just sort of like, well, it's the law, we have to follow it. Well, no, that's not how international law necessarily works. So do take the time to read about that. The sources are below in the notes. Also, the timestamps are below. It's a little late for me to tell you that, I know, but if you want to come back and just watch one certain part, you skip around and use those timestamps. But that's what I've got. What do you guys have?
So, building on the point that you need to use 30 to 45 seconds to introduce the judge to the topic and to what UNCLOS is, keep it simple with your case. You're going to be distracted by hundreds of arguments, especially if you're the pro. There's so many ways you could go, but a two-contention case could very easily win it if you're strategic. So in this case, focus more on the quality of your arguments and how well they're structured, with first your claim, then your link, then your impact, explaining in detail why it's important and why it's relevant to your judge. That's so much more important than having a ton of arguments and spreading. Second of all, in this case, especially if you're the pro, you want to demand some links. A lot of people are going to tell you, well, this could happen, well, that might happen, but you need to have a definitive link between acceding to UNCLOS and something actually happened. And vice versa, if you're on the con, you need to have empirical proof that something will happen. So if they say, oh, you're going to be subjected to environmental lawsuits, well, has that ever happened before? And if it has it ever gone anywhere?
Right. Yeah, you're going to have a lot of people saying some scholar in some journal somewhere said this might maybe sort of lead to a little bit more certainty or a little less certainty here. And you're going to have to develop skills as a debater to ask questions about that. Who is this scholar? What is their expertise? Exactly how much harder is it going to get? And then even better than those are sort of generic questions we can ask about all sources, but to be able to ask specific questions like, for example, on this idea of interdicting vessels, are you seriously saying that there's going to be a significant chance that we're just going to let terrorist vessels go, that because we signed some piece of paper, we're just going to let terrorist vessels go, and be able to explain just how practically ridiculous an outcome is in some cases, and the fact that some guy in some journal or some magazine said that there might be some connection, just point out how tenuous and attenuated it is, and you'll sound smart. You'll sound like you really know what you're doing, and it's an important debating skill. I'm sorry.
Definitely keep it in perspective. Don't get so stuck in debate world where the only things that exist are your contentions and your sources. Keep your common sense. Be rational about what your opponents say. If it seems unreasonable, it probably is.
Yeah,
let Josh take over.
Yeah, rather than thinking, just to close that off, rather than thinking, oh, I've got a block for this, think, do I even need a block for this? Could I save 10 seconds on the speech and rather just ask a really good question that's going to throw this entire thing into a realm of invalidity? That's those kind of things you just need to come with practice,
Let me
especially on a
interject
topic
real
like
quick.
this.
For those of you who are novices and don't know, a block is an argument that you make ahead of time in anticipation of someone else's argument. So as a debater, I would always go to my con case and write all my arguments against it and make those my blocks.
Yeah, you're gonna, guys. I'm telling you again, novices, it's tough. Hopefully, you have some varsity folks, but if not, having a couple of sentences and a source, at least
Just ready to go
on every possible argument. Just a big old binder full of them, or if you do it on a laptop, fine. I actually prefer putting them on pieces of paper so you can physically move them around. But having those at least little short blocks ready to go, many of them. There's just no other way to do it on a topic as broad as this.
And I mean, that pretty much the last thing I'm going to say is. We joked about this, but basically on a topic like this, you're going to have those blocks ready, because this is one of those that if we had to choose it in the way that we debate in IPDA,
we get to strike topics we don't like.
This would be one of the ones you would strike first or second opportunity.
Yeah.
Like, you would not debate this because it would be impossible to do, and if you did, it would be a slog.
But here you are.
Here you are.
And that's okay. We're kicking off the year. But here's the thing. If it's hard for you, it's hard for everybody.
Yeah.
And like we try to like work in a Fortnite reference every single time. So, if you're dropping into the map and it's hard for you to hit your shots.
Yeah,
and
dropping tilted. You're going to have a lot of competition. It's going to be hard, but it's hard for everybody.
It's hard for everybody in Tilted Towers.
Dropping in
yes,
tilted.
Everybody in Tilted Towers has a hard time dropping in. So that's okay. You'll get better by playing the hard matches. There you go. That's good, Josh.
I was
Very
thinking
good.
Dark Souls.
Oh,
The first
God.
thing
Yeah.
that came to
This
mind.
is the Dark Souls.
This is
of
the other
topics.
ones you just have to get good on.
Okay.
That's it.
All right. So yeah, get good. Okay. So anyway, well, listen. Thanks very much, guys. This is our episode for September, October. We're going to be coming back for all of the topics and also doing a few shorter videos on just good debating in general. So if you like it, give us a like. Please subscribe. Let your friends know. If you don't like it, let your enemies know.
Yeah.
But hit the bell for notifications. All that YouTube stuff they say, and we'll be back in a couple of months on this, and maybe sooner on some other couple of months,
a couple of weeks.
Yeah, sorry, that's the way it works. A couple of weeks, but we'll be back fairly soon. And hey, guys, we're kicking off the year on a good note. Good luck, and we'll see you out there.